Take your time, if you're all ready. So this means a good one,
Good morning, Your Honor. May it please the court. Your Honor, I represent the appellants. One Win and Hugh Win, they're actually sisters, Your Honor. One doesn't speak English that well, and the other one is mentally ill. Your Honor, this appeal is about.
And before we begin, would you like to reserve any time for rebuttal?
Yes, Your Honor, 5 minutes.
Very good. And I'm gonna ask you one more thing then. Could you put the microphone closer to you so I can hear you? Much better. Thank you so much. Go ahead.
Your Honor, the background of this case is auto negligent case that happened on July 14, 2022. And the Win filed their lawsuit in June 2023. And then an order setting trial was entered in December 2023, Your Honor, setting the case for a pre-trial conference for November the 7th, 2024. Your Honor, basically, the appellee wants this court to affirm the decisions of the lower case because I was sick and wasn't able to attend the November 7th, 2024 pretrial hearing.
Can I ask you a question though? As I read this case, the question just kept boiling out of me is why did you not file a motion to continue the pretrial, a sworn motion that said I'm sick, I can't come?
Your Honor, I was so sick. I had a really high fever.
How about your husband, who's a lawyer, who eventually got involved in this case? Somebody couldn't have done the normal thing that lawyers do, file a motion to continue the pretrial with a verified motion saying this is why.
Your Honor, because I was the only attorney that appeared in the case. Mr. Meacham is my husband, and he had.
I understand that, but he ultimately tried to get involved to help you. Why didn't he just help you file this routine motion that all lawyers would file?
Your Honor, because he did as I asked, which was to notify opposing counsel and the court that I was ill and could not attend the pretrial conference on the 7th.
We've all practiced law before, and we've all been sick before.
Yes, Your Honor, and for the 25 years that I practiced as a solo practitioner, this never happened before. This is the first time that it happened, Your Honor. And Your Honor, I don't believe that the Win should lose their case or get their case dismissed because their attorney got sick and could not attend the pretrial hearing.
Well, let's talk for a minute about your motion for relief from the dismissal order. Your friend on the other side makes a point about that you didn't submit any sworn testimony or affidavit or other evidence to support that, which generally under the law enables the trial judge to deny it without further ado and pretty much insulates review on that. So what happened with that? Can you explain how we're supposed to work around that?
Your Honor, I'm asking this panel to look at the record as it appeared in the record, because I'm not trying to add any new facts, Your Honor. The law doesn't require, Your Honor, because what would the Wins be sworn to? I'm the one that was sick. I'm the one, the facts is with me, Your Honor, and I signed that motion.
And that's not my question. My question is, ultimately, this record doesn't contain any sworn evidence of the reasons why you think the trial judge should have reinstated the case. The facts that would support that request, and that's what your opponent has argued with good law. So I get that you want us to look at the whole record and the client shouldn't be penalized for you being ill, but that's a question you're gonna have to confront to get us to a resolution.
Your Honor, as I stated, I signed that motion. I'm the one that had the facts that I was ill. The Wins doesn't have knowledge that I was
You can
ill.
verify it.
Your Honor, I signed the motion. I mean, my signature is a verification that it's true, Your Honor. I mean, I normally don't sign motions that have fraudulent facts in it. And Your Honor,
And let me see if I could shift gears. Ms. Benjamin, looking at the record, your husband did in fact send an email the day before, not just to opposing counsel, but also it looks like to the court.
that's correct, Your Honor.
And basically in his email, it says that you were sick, the flu or some other illness, that you really were trying to see if you could get better. And you, I'm paraphrasing it, that you were not. And it's like, please, we just want to, and this was sent by email. So the court must have had something in the record. And the other attorney, it looks like Doris Vokes. It was sent to Doris Vokes at the law firm. And it looks like it's the court, the Circuit Civil Division. And so that email is part of the record.
That's correct, Your Honor. That's part of the motion for rehearing.
And did the judge consider this email? Did the judge trying to say that that was not good enough or what?
I don't know what happened at the hearing, Your Honor, but I know that opposing counsels, and I didn't get this email on that date, of course, but opposing counsel says that the court was waiting for one of us, which means either me or Mr. Meacham, but Mr. Meacham never appeared on the record and cannot appear at a pretrial because only a trial attorney for the case could appear at the pretrial, Your Honor. So,
And what's interesting for me, that email from the other side made reference to your husband. And the only time your husband appears is that email that was sent the day before.
yes, Your
So
Honor.
that tells me that they got the email the day before. So the court got the email the day before. And we don't have a record, we don't have a transcript of what transpired at the hearing, but I would imagine, especially, we all know that we want cases to be resolved in the manner in which they resolved and not like, oops, gotcha, somebody's sick and not getting to the resolution. So I guess my question is that the only way that email was one of you, that means either you or your husband, led me to believe based on this record that they knew this email because that email was sent to them the day before.
I also believe that they knew, Your Honor, and I believe that there's not any evidence, competent, substantial evidence of support or dispute that I was not sick. So, Your Honor, that's why I'm here asking the court to reverse that dismissal order.
Because the record, as we reviewed, there's two emails, one from you on Tuesday saying, I'm not feeling well. I can't make it. Please reschedule. And this is to the other side. And then, of course, silence. So the next day, it must have been the next day when you're still not feeling well. That's when your husband sent that email that I made reference to, still silence. And then you get an email. When I say you get an email from the lawyer saying one of you, the judge is waiting for one of you to show up. I don't know, maybe that's a more question for the other side. That troubles me a great deal.
And when you're talking about when you say that the findings are supported by substantial competent evidence, you're referring to the paragraph 1 and the order dismissing. That says the counsel for plaintiff failed to appear to deal notice of your hearing and did not notify the defendant at any time requesting a hearing schedule. Is that my understanding your argument correctly?
Yes, Your Honor, and Your Honor, it's you know, the email from opposing counsel saying one of y'all should appear, it can't be one of y'all, Your Honor, it had to be only me and I was ill. Mr. Meacham never made an appearance in the case. And was only sent that email on my request because I was too ill to do it.
So what's our standard of review for what the court did?
Your Honor, I raised 5 issues, and issue A, which is because Your Honor, what happened was the car accident happened in 2022, and then in 2023, Your Honor, the law changed to where you don't.
I get all that, but the court dismissed your case based on all the things that we've talked about. So what is our standard of reviewing a court's decision to reverse your case? Is it abuse of discretion? Is it de novo, or what is it?
Your Honor, I raised 5 issues, and 3 of the issue is de novo, and the 2 other issue is by abuse of discretion.
Okay, which issue is by abuse of discretion?
Your Honor, issue B, which was the finding of facts that was relied by the court in dismissing this case without competent substantial evidence, that should be reviewed by abuse of discretion.
Well,
And
I mean, what the court pretrial order says, if you don't appear at the pretrial, I could dismiss your case. You didn't appear at the trial, the court dismissed your case. Is that abuse of discretion?
Your Honor, the court made it look like I was able to appear, but did fail to appear or did not appear. I wasn't able to appear, Your Honor, because of my sickness. I wasn't able to appear.
All right, again, is that abuse of discretion or is that de novo?
Your Honor, I have in my brief that issue B should be abuse of discretion.
So if we were to accept your argument and we were to reverse the trial court, theoretically then we would be writing an opinion that said, instead of appearing at a pretrial pursuant to a pretrial notice that says that if you don't appear, the case will be dismissed, you can send an email the day before to opposing counsel and to the judge just to let them know that you can't be there because you're sick, and that's enough. Do you want us to make the law be that way?
Your Honor, Your Honor, I want the panel to reverse the dismissal order on the de novo issue, which is I asked the court below to give me a rehearing or a motion to vacate, Your Honor, and that, Your Honor, you could find that on a de novo issue.
Well, you filed a motion for rehearing, right?
Yes, Your Honor.
And it was denied, right?
Yes, Your
And
Honor.
you argued that you should have had an evidentiary hearing, right?
Yes, Your Honor.
Did you ever ask for one?
Your Honor, I asked for a rehearing. That's another hearing where I could put on evidence of evidentiary evidence that I was ill, Your Honor. But the court didn't even give me that opportunity, especially since I wasn't able to make the argument on the 7th, and then to have the court not even give me a hearing.
But your motion for rehearing wasn't verified. You didn't attach affidavits. You didn't give anything for the court to think that, hey, I need to hear this again because I've got sworn testimony pursuant to this motion that says these are the way things were. So you didn't ask for a rehearing. I mean, you didn't ask for an evidentiary hearing. Court didn't give you one. It was kind of, nobody said anything.
Your Honor, the law, the precedent and the law is that I don't really have to ask for an evidentiary hearing, Your Honor. As you see in my brief, I've cited cases where
Well,
they.
Okay, but so you assume that the court would see your motion and on its own order an evidentiary hearing and set a hearing date.
Your Honor, I was hoping that the court review my motion, see the 2 emails that were sent, and grant a hearing, Your Honor, wherein I could put on the evidence of why I did not appear at the November 7th pretrial conference.
Isn't this all solvable by just filing a new case?
Your Honor, if I'm correct and the case has a 4-year statute of limitation, I can always refile it. But I can't refile it in this case, Your Honor, because opposing counsel have filed a motion for fees.
Sitting here all this time has passed and you still haven't filed a motion, filed a new case?
Your Honor, if I'm correct, then I can file a new case. I'm still hit with the fees for the entire case below, Your Honor. So I'm hoping that this panel could reverse that so we can resolve this case on the merit, Your Honor. Your Honor, y'all have any other questions?
If you would like to stop that now, you'll have your 5 minutes for rebuttal, okay?
Thank you.
Thank you, ma'am.
Good morning. May it please the court. My name is Brandon Tyler, representing Mark Williams.
The trial judge had noticed that she was sick and couldn't come, right?
According to these excuse me, I'm a little sick myself. According to these unauthenticated emails, yes. And we only see one side of the story. We don't know if there's other emails that are part of that chain. But I think this case boils down to that lack of sworn evidence. There's no verification, no affidavits, nothing authenticating these emails. And
I guess my problem is, if somebody's really sick, I mean, just common courtesy, professionalism, you get an email from her the day before, not the day, on November 5th saying, I am sick, please reschedule, silence. The next day from her husband saying, I waited to see if she could get better. She's really sick, whether it's a flu or something else, cannot make it, and then emails you. When I say you, the proverbial your office, emails the judge's office, and then that unprofessionalism, what would it hurt to just reset the pretrial? And then to take the implication, oh, is that really legitimate or not? I don't know. I'm really having a hard time with that. I realize that, okay, it was not sworn. Is she going to be able to, okay, she's sick. Oh, let's get a notary in here. I'm really sick. Let's be reasonable about this. And where's the professionalism in here and trying to work this out as opposed to the case got dismissed. Yay, we won one on the fact that somebody else was sick. That really concerns me because that's not what the practice of law is all about.
I understand the concern, Your Honor, and I do see that. That's why I bring up that we only have that one half of the story. And like I said, it was never authenticated, which I think is putting the cart before the horse. And then she filed a motion for rehearing and relief of judgment. Rehearing, she had 15 days. There's no indication on the record that she was sick for 15 days. Motion for relief of judgment can be filed. There's a due diligence requirement anytime within a year, also due diligence. She had time to get an affidavit, so I don't think her sickness would have prevented that. At least nothing in the record suggests that. And so I think, well, I see the concern. I just don't know what happened below because we have these 3 unauthenticated emails. We don't know what happened in response to that. I don't want to cast aspersions. For all I know, there could have been emails that were omitted that were in response to those. We don't know. There's never any sworn evidence.
What's in the record. And how about in response to her statement that she's an officer of the court? So whatever it is that she puts down in that pleading, that she's attesting it to be true as an officer of the court.
I would respond to that twofold. First of all, I heard her say that she signed the motion for rehearing and relief of judgment. That's not true. She signed the certificate of service, so she certified the service was made. There's no signature on the allegations of the motion itself, much less a verification. And then, sorry, if you could just repeat your question, please.
No. Her statement was just a few minutes ago. She said, when she was asked how come things were not verified, she said, I'm an officer of the court. And as a lawyer, as an officer of the court, whatever pleadings that you file, you attest that what you're doing is correct. And this is her position, is that she did not need to have it verified because she is a lawyer. She's not indicating that there's a witness and this witness is going to testify. And for that other witness that she has in the pleading, it happened to her. And she is the one who's indicating that in the motion. Does that make a difference?
I don't think it does, Your Honor, because the case law repeatedly says unsworn representations, even of counsel, is not sufficient. I mean, lawyers say things all the time. Some are more ethical than others. I'm not suggesting opposing counsel is unethical, but we just don't know, and the motion wasn't even signed. So there's just nothing preventing her from filing an affidavit, 15 days or even later after this dismissal order. And so I think that's really what this case boils down to is, one, the lack of sworn evidence. We talk about evidence in the record. There's no sworn evidence in the record. And two, Judge Morris hit on the standard of review we have, which is not just abuse of discretion, but gross abuse of discretion, the judge reviewed the argument and she found, presumably based on the lack of sworn evidence, at least in part, that there was no relief, no grounds for relief. And so I just don't think there's been a gross abuse of discretion shown here. This isn't to know.
I'm curious, has there been a pattern in this case? Not that we have what's before us. Has there been anything before with failure to show up at prior hearings or anything like that that would indicate to the court that that's it, we'll dismiss this whole thing?
So there was in part, and first of all, opposing counsel hasn't raised issues with the dismissal order itself. It's just the motion for rehearing. There was a failure to appear at a November 5th hearing, which the motion for hearing explains was on a motion to strike. She alleges that was part of the sickness too.
November 5th is when her email was that she was sick that day. I'm talking about something.
There was a
prior
hearing
to
and
that.
then the pretrial conference. There are two separate, which isn't clear in the record. The motion for hearing states that. But part of the problem is we don't have the transcript of the hearing. And so perhaps there's something that's not apparent in the record. And
we can't go there. I'm just saying that
Correct.
what's in the record before us right now, from what I reviewed, there has not been a pattern of a failure to appear by her in the course of this case, based on what's in the record. Am I correct?
not so far as the record shows. Correct.
Okay, so I am correct.
Yes,
All right.
that's correct. But as I said, there's no transcripts. We don't know exactly what the judge considered at the hearing, and it's a review for gross abuse of discretion. And so, and again, there's no independent issue with the face of the dismissal order. It's more just the failure to consider these facts that were alleged in the motion for rehearing or relief from judgment. Given that there was no sworn evidence in the record and under standard review, I think this court is compelled to affirm. Thank you.
Thank you, sir. I have like 5 minutes for rebuttal.
Thank you, Your Honor. Your Honor, I've never missed a hearing in this case before. The November 5th illness leading up to the November 7th. The motions that I filed were timely, Your Honor. And as I stated before, the motion doesn't need to be sworn, Your Honor, because there's no other witness, there's no one else. Not my client doesn't have the fact that I was ill. I'm the one that was ill. And I signed that motion, Your Honor. So, Your Honor, I'm asking the court to not make the win-lose their case because of my sickness. Thank you, Your Honor.
Thank you both. All right, and I think this concludes this morning's docket. The court is adjourned.
All rise.